I'm going to stand here and I'm going to get started, and I'll use the mic if I walk around. Hopefully I'll remember. So if I don't, just somebody shout at me. Once again, my name is Katarina Delisle, and I'm one of the attorneys in the Office of General Counsel. And so what I do is I work with all the journalists in Voice of America and also in the Office of Cuba Broadcasting on a variety of matters, one of which is copyright and fair use. So this presentation is a joint presentation between the Office of General Counsel, and I'll be doing that part. And that section is on copyright and broadcasting with an emphasis on fair use principles. And the second part of the course is taught by Boyan Klima, who's standing over there, from the VOA Video Archive Service. And Boyan's part of the presentation is just going through the three main video news feeds that the Voice of America subscribes to, and going over the common restrictions that you should be aware of when using those video news feeds. So I'm going to go ahead and get started. Usually I take questions as we go, but I'm going to ask you to hold off questions until the end since we're recording this today. So just kind of note your questions for the end. I'm going to go over some basics of licensing, kind of define copyright for you, define public domain and fair use, and then we'll go into some examples of fair use and so forth. We'll end with just a brief discussion on trademark so you know the difference between copyright and trademark. Some of you may be aware of many of these concepts, and for others they're pretty new, so I go ahead and sort of do all the introductory discussion, so just bear with me. I will be talking about artistic works that are copyrighted, and when I talk about our use of those works, it doesn't matter what platform you're working for, whether you're a radio broadcaster or whether you publish articles online or social media. It doesn't matter where your work is or where you find the artistic works. The same rules will apply to the whole discussion. So where do we get rights to use artistic material that's copyright protected? Well, importantly, we get it through licensing agreements or contracts, right, that the Voice of America enters into and pays for. And those are sometimes called licensing agreements. Sometimes you'll hear the term rights releases. Sometimes you'll just hear the term contracts. They're all the same thing. And chief among those are the ones that are the subject of the second part of this class, which is Boyan's presentation. Our contracts with Associated Press, Reuters, ABC, those are examples. Other contracts that Voice of America has are with wire services, some of the same providers, and with photo services also for photos. So what's important to keep in mind is the terms and conditions of those agreements govern our use of those works. I tell you that because we'll be talking about fair use, and fair use presupposes that you do not have permission to use a work, okay? That you don't already have an agreement that covers how and when and why you can use it. So that's important to keep in mind because our contract terms and conditions will trump fair use. So you can't have a fair use override what we've already agreed to with a certain provider or copyright owner. So contracts don't just allow necessarily blanket permission. Sometimes our contracts allow us to use a certain work only a certain number of times. Sometimes it's only on certain platforms and not others. Sometimes, for example, internet use is allowed, sometimes it's not allowed. So just keep that in mind. There are also sometimes limitations on the time that we can use a certain work. So we might be able to use it for a week and then not again after that. So now I'm going to launch into some definitions, what copyright protection means, what it means to be a copyright owner, what public domain means. So copyright protection is a form of intellectual property right for original creators of artistic works. And when we say artistic works, I mean things that you might think of immediately like painting and literature, but we also mean photographs, video footage from other broadcasters, music, again, literature or newspaper articles, graphics, illustrations, cartoons, those are all considered artistic works. So as a copyright owner, the owner has the exclusive right to reproduce that work, distribute copies of that work, display that work publicly, and to give permission for others to copy that work and display it, or not to give permission. Sometimes alongside a work, you'll see that symbol C. That means something is copyright protected. but that is not required to display that for copyright to attach. In fact, copyright attaches automatically upon the creation of the work when the work is fixed in what they call a tangible medium. All that really means is when I click that camera and take a photo, copyright attaches immediately to that photo, okay? And what's important to keep in mind is that just because something is easily found online, it's all over social media, it might be on YouTube, it might be on other platforms, it doesn't mean it's not copyright protected. In fact, that has no correlation. If something's really readily available and very visible, and you've seen that graphic on Facebook and YouTube and Twitter, it doesn't mean that it's fallen into the public domain. So what does public domain mean? Still on this slide. Public domain means that something is not protected by copyright at all. Okay, and that's going to be a pretty narrow category of artistic works. You're not going to be able to take advantage of that too much. The general rules of thumb are any works that are really old, and what we're talking about is prior to 1923. That's a good rule of thumb. So how often are you really going to be using artistic works that are that old? Not that often in your work as a journalist. It happens time and again. I remember someone wanted to use a photo of the Titanic from 1905 or so. That was in the public domain. And then the second category of works that is in the public domain is U.S. federal government works created by employees, government employees within the scope of their duties. So all of us as Voice of America full-time employees, when we're creating artistic works as part of our job duties, copyright does not attach to those works, okay? So we're only talking about the U.S. federal government. That's important to remember. We're not talking about state governments, not local governments, not nonprofits. That's not the U.S. government. We're just talking about U.S. federal government works. Those are going to be in the public domain, which means not protected by copyright. So when something's in the public domain and it's not protected by copyright, you don't have to worry about licensing. And you don't have to worry about the fair use principle, whether it applies or not, the balancing test we're about to talk about. A public domain works that means that it's free to use as much as you want on any platform you want, okay? But again, you have to be really sure that something's in the public domain before you go using it without a permission. Okay, so let's start talking about the fair use doctrine. It's basically an exception to the general rule that you may not use a copyrighted work without permission, okay? And again, how do we get permissions? We get them in writing via licensing agreements and contracts. We sometimes get permissions orally too from a copyright owner. So the general rule of thumb, you have to get permission to use a copyrighted work. And if you don't get permission and copy a copyrighted work, then that's called copyright infringement, and that's illegal. And there's a big carve out that applies to educators and the news media, and that's called the fair use doctrine. It's basically a defense to a copyright infringement lawsuit, and it says that, well, there are times where it's okay not to ask permission, and we can use a certain work within sort of these fair confines. It's a privilege to use the material in a reasonable manner without the consent of the owner. How do we know if something's a fair use or not? The big question, right? Well, we look at 4 factors each and every time. The purpose and character of our use, the nature of the copyrighted material, the amount of our use of that material, and the effect on the potential market of that material. This is a case-by-case analysis. It's a balancing test. So it's very fact-specific. Something that may be a fair use in one scenario will not necessarily be a fair use in another scenario. So let's go through each of the factors one by one. Purpose and character. Here we're really asking whether our use is transformative. I don't know if you guys have heard the term transformative, but it's really key to the fair use analysis. Transformation occurs when we alter the original with a new or different purpose. So instead of playing a song to entertain audiences, which is the purpose of the song to begin with, we might play a clip of a song because we're doing a music review of a newly released CD, right? So that's a transformative use, because why would we do a music review of a newly issued CD? Well, for review purposes, for critique and criticism, okay? So that's a transformative use. On the other hand, if you have a 30-minute show and you've only filled up 27 minutes of it with prepared material and you don't have anything to fill the last 3 minutes, so you just play an entire song at the end that has no relevance to your show or any of the subjects you covered, that would not be a transformative use, okay? So that would not be a fair use. Let me give you some more examples of transformation. Let's say you're doing an obituary on Philip Seymour Hoffman. Died recently, an actor who died recently, right? As part of your obit, it probably will be interesting, whether you're doing a radio piece or a television piece, to actually play a few clips of some of his most famous movies, right? You might play a clip from, what was he in? Doubt, Ides of March, Charlie Wilson's War, right? What else was he in? So you might play, I don't know, 10, 15, 20, 30 seconds, however long you need to. And for what purpose are you using those clips, those movie clips? For purposes of the obit, so as illustration and example of his life's work. So that using those clips for illustration and example is also a transformative use. And that use in the obituary would be a fair use of those copyrighted movies. Let me give you another example. Let's say a cultural reporter is going to cover an exhibition at a local gallery. And that as part of that report, the reporter is discussing the works in the gallery, critiquing them, getting opinions on them. Displaying those works at the gallery, which would be copyright protected, would also be a fair use. Okay? And I have this example, using a song just as background music or using footage just as B-roll would not be transformative. So, for example, if we didn't go out and cover a story and another news organization did, can we just pick up their footage and use it as B-roll? Without permission, without a licensing agreement? No, because that would not be a transformative use of the other broadcaster's copyrighted work, because the purpose is the same, right? We're not transforming their original work. Okay, the second factor is how artistic a work is, the nature of the copyrighted material. So the more artistic a work is, the greater protection it'll get under copyright. Remember, facts are not copyright protected. So going back to our other broadcaster example, if another broadcaster interviews a newsmaker and that newsmaker says something very newsworthy as part of that interview, you can always report the facts on what that newsmaker said. You just can't play the NBC interview, for example, without permission, of course. Remember, audio, video clips from other broadcasters, photographs, music, they're all considered artistic works. The third factor is substantiality. Here we're looking at the percentage of our use and comparing that to the length of the original. So in my Philip Seymour Hoffman example, using 15 seconds of those 3 movies I mentioned is a really insubstantial. It's a small portion of the length of the movies originally, because they're about 1.5 hours to 2 hours long. So you're really using a very small percentage. The other consideration here under this factor is whether you're using the heart of the piece. So here we're really talking about, you know, in a movie review, don't give away the ending. Because that will also have an economic impact on the movie and whether people go see it or not. Normally, a few seconds will likely be a fair use, but again, it depends on the length of the original work. I have heard a lot in journalism that 30 seconds is always okay. It likely is, but there's no such rule in copyright law or in case law on it. 30 seconds may be okay 95% of the time, but if the entire work is only 40 seconds long, well, then you've just used a very substantial portion of it. Does it necessarily mean it won't be a fair use? Not necessarily, but it's weaker on this particular factor because you've used a more substantial portion of the work. So there's no rule of thumb here, unfortunately. The rule is use no more than necessary to illustrate whatever point you're making. You know, journalistic standards matter here too. What is reasonable in that particular situation? How much of the work you're going to be using? And the last factor is, does your use interfere with the sale of the copyrighted material? So the interference must be related to the potential market of the original work. So here you're going to think about, for example, an independent photojournalist posts something on his blog, let's say. Can we just copy and paste that photo from his blog and use it on voanews.com? No. likely not, it's not going to be a fair use. One of the reasons is this fourth factor, because an independent photojournalist is in the business of selling his photographs to, guess who? News organizations like us, right? That is his livelihood. He does that for a living. He licenses his photos to news organizations working for himself. And so our copying and pasting of that photo without permission would likely be copyright infringement, and it would have a negative effect on the market of that work, which is geared towards newspapers and broadcasters and other media organizations. Same as if we all went to go see the latest movie that's out right now and brought our phone and recorded the whole thing and uploaded it to the internet. The theory is that fewer people are likely to go and buy a ticket to go see that movie. So our copying of that artistic work would also interfere with the sale of that copyrighted material. I'd like to mention here that in my photo example, photos are rarely going to be a fair use. And the reason is that they fail on this factor entirely. In general, you're likely to use 100% of a photograph. So it's a very substantial part, it's the whole thing. So it's unlikely that using a photograph will ever be a fair use. There will be times that it is a fair use. If the photo itself is in controversy somehow, and that the photo or something about it is this very topic of your story, then displaying that photo for purposes of critique, criticism, or illustration might be a fair use. But that'll be less likely. All right, so who are the authors of copyrighted works? It's important to think about that because sometimes, let's say you want to use a photo that you see on Facebook and it depicts the Facebook user's face. Well, likely they are not the copyright owner of that photo. It's most likely the person who took the picture and not the person that appears in the photo. If, let's say, you interview a university professor from the University of Maryland, and you need a photo of that professor, and she tells you, well, just take the photo from the university's website. Well, you have to ask, are you the copyright owner of that photograph? Because likely in that kind of setting, if it's the university's webpage, the copyright belongs to the university, and you would have to call their public affairs office or whoever and ask permission from the rightful copyright owner. So authors are often the owners of the work, but if it's what we call a work for hire, where a reporter is taking photos for a newspaper, and that reporter is, an employee of the newspaper, it's likely to be the copyright owner is likely the newspaper or that organization, and not the photographer herself or himself. So you have to think about who is the rightful party for me to ask permission from. And some creators also assign their copyright to an agency which manages licensing for them. Instead of dealing with granting permissions and negotiating fees themselves, they might have let a professional licensing agency do that for them. Also like to mention Creative Commons here. It's a licensing system many of you have probably seen online. So as the creator of a work, I can put a Creative Commons license on that work and decide how I want to allow people to use it. Oftentimes it's for non-commercial use and with attribution. The Creative Commons licenses are pretty reliable, but again, you're not going to see them that often. So it's going to be sort of a small pocket of works that you're going to be able to rely on that license. So when relying on licensing in general, we're not talking about fair use again. We're talking about permission that the copyright owner has granted in a certain way. Okay, so just to tie up this topic and give you some tips, again, there's no specific number of words, seconds, or notes that may be safely taken without permission. Fair use, like I said, is case by case, very factually specific. Attribution is a key sort of ethical rule for a journalist. Acknowledging the source is always important when the source is not you. But just because you attribute a source does not mean that you're not infringing that work, okay? They're two separate concepts. And then an important last point, always check the video library before turning to any online resources like YouTube. We have a lot of things in the video library that we already have permission for, that we've paid money for via licensing agreements or otherwise. So that should be the first place you start always before you turn to anywhere where you may not have permission, such as YouTube, okay? Another tip is check terms of use on websites. You'll find a lot of interesting information there. For example, I put the State Department website, and their terms state that unless a copyright is indicated, information on the State Department's website is in the public domain and may be copied and distributed without permission. So if you know something's in the public domain, again, you don't have to do the fair use analysis. I put another example from cspan.org. The terms provide, under C-SPAN's copyright policy, a license is generally not required to post a recording of C-SPAN's video coverage of federal government events online for non-commercial purposes, so long as C-SPAN is attributed as the source of the video. There are a few other conditions on that page, and that page defines what a federal government event online is for you. So there's no ambiguity. If there is any ever ambiguity about the terms of service, you can call our office to help read that through with you, or go ahead and call the licensor, the copyright owner, if you're not sure. To assume is not to know. So if you're not sure, it's always best to ask. Okay, and I'm going to end just defining trademarks for you. Trademarks are different than copyright. Trademarks are logos, names, slogans, or symbols identifying products or companies, okay? So the Coca-Cola logo that we've seen our whole lives, I have Amex there. The Voice of America logo and the words of Voice of America are also trademarks of the BBG. So what is trademark infringement? Because it's a little bit different than copyright infringement. Trademark infringement is using another person's trademark, so their logo or their name, in a way that's misleading to the public about your affiliation with that company. So this is not going to be relevant too often to you in news broadcasting, because if you're reporting on the stock prices of Facebook, and you show the Facebook logo, that's fine in news reporting. That's not trademark infringement. Now, if you started a social media company similar to Facebook and you called yourself Facebook or something similar, then you would have a problem, because you're really capitalizing on that well-established mark of another organization, okay? So that might constitute trademark infringement. But your general use of trademarks in news reporting will not be trademark infringement, because the public is not confusing you with the company. If I started selling sodas and called myself Coca-Cola, I might have a cease and desist letter from Coca-Cola saying, please stop using your trademark. The idea is that it would be easier for me to sell sodas using their well-established mark than if I came up with my own name and logo and so forth. Sometimes we talk about releases. Releases are just mini little licensing agreements that you'll use as needed as a producer. So you might interview a musician and go ahead and ask permission during that interview to use several songs in your news report. There's a standard template rights release that we have on SharePoint. It's on the best practices page on SharePoint. And for those of you who don't know, SharePoint is the intranet for the agency. So you want to use that release when getting permission. A lot of people like to get permission orally, and sometimes in this business and breaking news and so forth, that's the only thing you can do. But there's a strong preference to get permission in writing. And there's a variety of reasons for that. One, because our standard rights release just kind of talks about all our platforms, about perpetual use of the work. If you don't use our release and just have a quick email exchange or just have a conversation on the phone, it's definitely better than not asking permission at all, but you may not cover certain subjects. For example, you might say, well, can I use your photograph for tonight's show at 7:30? And the person says yes. Well, what about if that show repeats tomorrow? Have you gotten permission just for tonight or for tomorrow? Maybe you haven't made that clear. What if that show is automatically streamed online, as all VOA shows are? Have you gotten permission for online? What about mobile? And then let's say your piece in your show becomes a hit and the rest of Voice of America language services start using it. Have you gotten permission just for your language and just for that show, or for other Voice of America shows? What about, if the TV Marti wants to use your show? So by getting permission in writing using our rights release, all that's sort of covered. The other advantage of getting permission in writing is that memories do fade, and two people might remember a conversation in two different ways. So if we have a question 2 years down the road about whether or not we had permission to use a graphic that appeared in a story from 2 years ago, who knows? Maybe if you're an intern here, you might be gone, and maybe the person you had a conversation with might remember the conversation differently than you do. So those are all sort of plugs for why I like writing. Also, just a quick mention of minors. If you're interviewing anyone under 18, you should be asking their parent or guardian to sign a rights release. And that is a standard template form that we have on SharePoint as well. When you're interviewing adults, unless it's a really special case, and in that case, you'd probably talk about it with your editors, and we talk about it together. But if it's a regular interview and you're representing yourself as a journalist, then their consent to be interviewed is consent enough. You don't have to get any permission in writing on top of that for them to appear on our air. So we're here for you in the future when you have a copyright, trademark, and fair use questions. All my contact information and for our office is in the handout that I gave you. That's called the Fair Use Self-Help Guide. That handout lists common questions and answers that we see over and over again. So read through that at your convenience. It also has our contact information on the third page. We ask that first, before you come to our office, you talk with an editor about your fair use question to sort of help determine an opinion from your end, one way or another, about whether your use would constitute a fair use or not. So that before coming to our office, please speak to your editor. We ask that you provide us with your deadline when emailing us or calling us with fair use questions, because you know, if your show is running in an hour and a half versus if it's a feature that could run anytime, for example, next week, that will make a difference in how quickly I respond to you and what kind of call we'll make maybe. And tell us as much as possible about your package or your story. Because this is so context specific, when if you only send me a link to some website and say, can I use this? Well, that's not enough information. We'll end up just having a long back and forth exchange because I will ask you these questions. First, I'll say, what's your deadline? Then I'll say, have you checked the video library? And what did you find there? Then I'll say, well, what are you covering? And how are you using this artistic work in your piece? How much of the artistic work do you propose to use? How long is the original, okay? And I'll want a lot of information about the angle of your story. Are you putting the copyrighted work in some kind of context? Are you making reference to it? It's more likely that it'll be transformative that way and a fair use. And the best email address is copyright clearances with an S at the end. So copyright clearances at bbg.gov instead of emailing me directly, because from time to time I might be out. I will stop here and answer questions, but one more point I thought of, which is sort of incidental recording of copyrighted works. So let's say you're at a protest rally and you're interviewing some protesters, and some protesters in the background are chanting a John Lennon song, for example. Are you supposed to edit out that song? Do you have to interview somebody else? Any ideas about that? I'll go ahead and take suggestions from you guys. So that would be an incidental recording of some copyrighted lyrics, right? Or even maybe the composition of that song in the background as you're interviewing somebody. Any ideas? And please turn your mic on before speaking. Yeah.
Sorry.
Yeah.
I think yes, because these areas are public area, and we can.
So you think we can use that, the chanting in the background?
Yes. Yeah.
That's right. So in that example, basically the copyrighted work is incidental to something else you're reporting on anyway. It would be very burdensome to require journalists to always avoid a poster in the background of something, a photo in the background of something, someone chanting in the background, or let's say you're in some kind of space where someone's car radio is up loud. That's an incidental use of a copyrighted work, and that's permitted also. So good answer. I'll stop here and go ahead and take questions, and the questions may be good for purposes of the recording too, so please press on your mic before asking a question. I know you guys have to have some. Good. We have one?
Yeah.
No.
I have,
Is your mic on? Great.
First of all, is any video that we receive considered as an artistic work or not? Any video that's coming, especially the news
That we receive from the outside?
outside is coming in. are just considered as artistic work or something
Right.
that you work on and make it artistic work? Because these days you get a lot of materials, like through the cell phones or such thing that the people are recording on the street and such thing comes in.
Right. You're correct that that would have less artistic value and it would be part of our fair use analysis under that factor too, about how artistic it is. So something that was shot by an amateur with their phone, you know, with them just going like this, would receive less sort of artistic value under that factor and therefore be more likely to be a fair use by us than a professional video from Reuters TV. So yes, that does make a difference. Most of the video coming in is from providers who we pay, though, but you're really talking about amateur, user-generated content and things like that, yeah. Yes?
Yeah, the follow-up question of what our colleague raised. In most cases, we receive videos from different incidents across the world through the Facebook or Twitter. So if someone is not doing the filming for professional purposes, for income, so I think we can use it and give the source that we got it from that person through Facebook, something like that?
Not necessarily, no.
Okay.
So you don't have to be a professional for copyright to attach, right? I mean, that's sort of the riskiest area is if you take from professional organizations that are in the business of selling that. But no, you can be an amateur photographer, and if you take the photo that appears on that amateur photographer's Facebook page without permission from that photographer, it could constitute copyright infringement.
So now, considering this scenario, can we use it or not?
No, not without permission, unless it's a fair use, and we'd have to talk about the specific instance, whether it's a fair use or not. So since it's case by case. Yeah.
We always request our tapes from video library,
Uh-huh.
but most of tapes, they have restriction.
Yeah.
And said no access to mainland China. And actually, our signal just broadcasted to Asian countries.
Uh-huh.
So in this case, what should we do?
What restriction are you referring to?
No access to mainland China,
Okay.
or part of the video, no access to mainland China.
That's a good question. It's covered in the second part of this presentation, which Boyan will cover, and he'll cover all those restrictions in the newsfeed, specifically the geographic ones. Boyan, tell me if I'm wrong, but to answer your question, the no mainland China does not apply to Voice of America. It does not. So you can use that and broadcast it to China. That restriction does not apply for our particular contract. So that's a quick answer to your question, but this is actually going to be covered in depth in the second part of this class. So.
Yeah, and by the way, if we cannot get a photo from Pacific website, whether we can show the whole page. The web PC can show that, the whole page.
From what website?
I mean, anyone. Because we cannot immediately get the permission.
Right.
Yeah. So in this way, whether we can just show the whole page, whole website page.
It really depends. I know that's not a very helpful answer, but we would have to go through the fair use analysis. Why are you showing the page? Is the photo somehow in controversy or the subject of your story or related to something you're discussing? The answer could be likely yes in many cases, but not always.
Okay. Thank you.
Did you have another one?
I have several, but let me just do it quick. YouTube. What is the story with that one? I know that we do have a little bug that we can use it on the YouTube stuff that we have, but how much, what story, and how far?
There are no different rules than anything I just talked about. Okay, so there's a lot of material on YouTube, and I know people turn to it pretty frequently. It doesn't, just because someone uploads something on YouTube doesn't mean it's theirs, okay? And it does not mean it's in the public domain. So you would do the same kind of analysis that we talked about in our examples with the 4 factors. And first you would think about if it looks like the person uploading the video is the copyright owner of the video, you would think about whether or not there's a way to contact them. Sometimes there is through YouTube if you can identify the source, and go ahead and ask if you can use the video. That way you're not limited also by only using 15 seconds or 20 seconds. Maybe you want to use the whole thing. Yeah.
The video, you said sometimes a video can be artistic work can be 30 or 40 minutes, seconds, and if you use 30 seconds of that, so that's kind of copyright violation. Is there any limitation by law that defines that 0.1% we can use?
No, there isn't, unfortunately, because the rule is meant to be flexible. Because what will be a fair use in one instance will not be a fair use in another. So it may be reasonable for you to use only 5 seconds in one story, depending on the nature of your use of that work, and it might be reasonable for you to use a whole minute and a half in another story. So there's no rule of thumb, unfortunately. Yes. Can you come up to a mic, please? No, but then it's not on the recording.
Okay.
Thanks.
It's not. Thank you. Okay, I'm a broadcaster. I'm not a producer. And on air in a radio, I have a magazine every Saturday, the Woman magazine in French, and there is an opening and a closing. And I did a kind of mix myself because I wanted something very special. I took things on YouTube. Before that, I asked to the production, and they were not aware of a lot of things, but they told me you can take anything on YouTube. So I did a kind of mix with people speaking, artists and songs, but I have at least 3 artists. Song artist, 2 contemporary, and Miriam Makeba from South Africa, which is a very old song. And so they are played every Saturday at the opening and at the closing. So my question is, I doubt now that, I have to ask something and have I to redo that? I would like to make sure.
Let's look at that together, sort of after the class offline. Maybe you can send me a link to the show Open and Close, and we can talk about it together. Your question is more complicated than might meet the eye, because there's a lot of copyrighted works involved there. There are probably several pieces of music and probably videos as well.
No, only radio. But sometimes
it's a radio show. I'm sorry.
But sometimes, for example, for the closing, when my show is shorter, I can leave Miriam Makeba singing for sometimes 1 minute, 2 minutes. So
that's and who is that artist? Is that an artist that we got permission to use a song or not?
This is what I don't know, in fact, because
okay,
when
so we'll need
I
to kind of drill down on that.
Yes. Okay.
Without permission, playing a song for 1 or 2 minutes at the end of a show would probably not be okay. But we'll need to think about who is the artist. Do we have some kind of relationship with him? Did we get oral permission maybe somewhere along the line? So we'll need to look at that.
Okay.
So just email me separately if you don't mind. Yes.
Sorry, we had a freelancer presenter in Afghanistan, in Kabul. So they did record some interview and some other stuff for West of America Afghanistan service. No, he is not working for the section, and still we have been using his interview and some clip of the interview, like for the attraction of audience. So what do you think about it? He's not working with the Voice of America for the moment, but from the past he did something, and we are still.
Oh, so he was like maybe a stringer reporter on the ground.
Yeah.
And at that time, he was working for the VOA and provided.
But for the moment, he's not working.
Yeah, so the kind of license that we get from stringer reporters that's standard in our contracts is a perpetual license that lets us use it forever on any platforms, repeat however many times that we want. Unless there's a very specific term that's worked out in a contract to the contrary, but those are going to be 99% of them.
Okay, thank you.
Yes?
One more question about the music. That the tape library you mentioned, the music library you mentioned before, that we do have it downstairs. But do we have a permission to use anything that we find over there, or just a portion of the production-wise that they have? And if you're talking about the production only, the production is virtually nothing.
Right.
It's just repeating a few melodies, for a few seconds, and it's repeating that one.
So, right, the production music is what we have licensing agreements and pay for to use, so you can use as much of that as you want. And the other catalogs of music are to be used on a fair use basis primarily. Yeah. Okay, there's a lot more training to take place on the video news feed, so I'm going to end here, but if you don't mind, Boyan, I'm just going to run through my Q&A slides really quick. Just to reinforce these concepts. These are quick, so just shout them out when you know the answer. Are you protected against a copyright claim if you properly credit the artistic work you're copying? Shout it out.
So
Louder.
are you protected?
No. Good.
Right.
Okay, so just attribution does not mean that you're not infringing, okay? Can we copy and publish material that we find through an online search engine like Google Images?
No.
No. It does not lessen its copyright protection, the fact that it's available on a platform like that. Does it matter how artistic the material is?
Yeah, of course.
Yes, this is the very good question you asked. So a highly creative piece of work is more protected than an amateur cell phone photo of a family pet, for example. Can we use the logo of a business like Pepsi or Facebook or Google without getting permission?
No. Without getting permission in public. Yes,
So here we're
it's-
talking about trademarks,
Yeah.
okay? So logos, remember we talked about the Facebook example, if your story is about how much their shares are going up or down. So if it's in connection with a news or feature story about the company, about the industry, that's going to be what you guys are going to be doing. Then about the popularity of Facebook, for example, then you can use their logo.
Can I ask?
Yes.
For example, if we are doing an interview for the TV, for like as a vox pop with the citizens, and in the background there is a trademark or a logo of Coca-Cola. So like
You don't have to structure your shoot to avoid
Yeah.
that. No, because, I mean, you're out, let's say you're out in the mall or something and there's a truck behind you, a
Yeah.
Coca-Cola truck behind you. That would also be sort of an incidental
Doesn't-
use of
yeah.
the trademark, so you don't have to worry about that.
no, okay.
This is a true false. Plagiarism and copyright infringement are the same thing. That's false. So a plagiarist is when you pose as the creator of something. An infringement is when you make an unauthorized use of a copyrighted work. Works without the copyright notices can be freely used. True or false?
Or is it copyright notice?
So the notices, as we discussed, are not required. As long as you use under 30 seconds of video, your use is always a fair use.
No.
Okay. I think we covered that in a couple of different spots. Like I said, unfortunately, no specific time limits in the law. Very case by case. Using content from a .org website is always okay. No, so that, yeah, people get confused about that. A .org usually signifies a not-for-profit corporation. That's not the U.S. federal government. That's different, right? So nonprofit corporations can and do hold copyrights. This is not a copyright question. It's my last one. Can we take and publish photos or video of people in public places?
Yes.
We talked about that a little. The general rule is that when a person does something in an area that's visible to public foot traffic, they don't have an expectation of privacy. And we talked about adults. If they're being interviewed by a journalist willingly, then you're assuming you have their consent. Okay, that's it for my part. Thank you very much, and I will stay